has been registered. Which have now I have been told that there is an application on order 7 rule 11. That is your lordship will deal with. So whichever date is convenient, because as we are late, the election.
No, I think election matters. It's a new matter, right?
New matter.
I think for that the Honorable Chief Justice will have
Has
to.
to be. Only we have to. I thought that there's the same
No,
petition.
no. Every time the Honorable Chief Justice
I
allocates a
will-
bench,
He will definitely.
he will have to move and then he will
Yes.
allocate the bench.
I am deeply obliged. Well, I thought that the matter is pending, maybe connected.
No,
Maybe, my lord, there is a new fresh election petition.
Hmm.
Basically, we'll put it before the register.
you can apprise the Honorable Chief Justice and he will definitely apply his
Yes.
mind because it is his prerogative to give
No,
allocate
correct,
a bench.
correct. Yes, I'm with you. Yes.
We are free to list one matter today.
Today is not possible. The opening day, because today there are bail matters also. I have to sign all the
On the
documents.
opening day,
On the opening day, you make
Okay.
give it to the court master.
Okay. please, your lordship. Lordship, I beg to mention item number 3. Item number 3, lordship.
3, I'm not adjourning. This item is a 2017 matter. I'll take it and then,
In this matter, lordship, we have recently engaged Mr. PK.
no,
Visram.
that I'm not concerned with that. It's a 2017 matter.
Yes.
Therefore, I'm not adjourning, just on a prayer. I'll take up the matter and then if required, I'll adjourn it. But not on mention.
May it please your lordship, I beg to mention item number 14. With the consent of the other side lordship, which will be taken after vacation.
The review by the state.
Okay.
Review petition by the state.
Okay, 14. On the prayer when well and counsel for the, you have taken consent of the other side?
Please lordship,
But I'm here, it was my review petition.
and for the respondent.
Oh,
I'm for
you are
the-
for the respondent, okay. On the prayer made well and counsel for the respondent. Matter stands adjourned today, list after ensuing revocation.
Obliged lordship.
May I please, your lordship. May I beg to mention item number 8, your lordship.
Just a moment. Wait.
The matter has become infructuous, your lordship.
Ah, yes, that's right. Okay, okay. Your name is okay. No, not required. Not required.
You
Your
can
name?
take it, your lordship.
Upon instructions, Mr. UK Dekal and counsel for the petitioner submits that the matter has become infructuous. Mr. Mr. R. Mizundar, understanding counsel for the secondary education department is present. Matter since closed because the subject matter has become infructuous. Okay.
Obliged, your lordship.
Obliged.
Supplementary order, those on the
I'll take up bail matters first.
item number 15.
May it please, your lordship. My lord, this is regarding that Butterdown police station.
Acha, I'll call for the
Yes.
Scan.
no, scan copy is already there.
Fine.
I just attached this record of BA.
Fine.
List on, give a date after BU. 21/4/2023. Along with record of BA 3370 of 2022, where the scanned copy of the case diary is available.
Obliged.
16,
No, please, your lordship.
Yes,
You know, this case, Stone arrested, your lordship, on 10.
it's an Arms Act
302 is there.
302.
case diary
Yes,
Fine.
on from which place, which police station? Which police station?
This could be, yes, your
This.
lordship.
Okay.
Third name.
17,
Why so long?
Vacation from today itself.
Okay. Well, just in these cases, you just write.
Then my lord,
No,
second.
no. In this case, charge sheet has not been submitted.
No, your lord.
No. As charge sheet has not been submitted in this case, instead of calling for the original case diary, the APP shall call for the scanned copy of the relevant pages of the case diary concerning the petitioner.
My lord.
Original will also come, my lord, from this school, my lord.
No, you see, then you can't, what you call, then you will be delaying your filing of the charge sheets.
Right.
I don't want this court's order to prevent
My lord, that is,
charge sheet from being filed.
my lord,
So wherever I'm calling for the case diary,
my lord.
just scan copy of the relevant pages of the case diary concerning the petitioner. Okay. When, give me the date,
3-5.
3/5. Make it on 28th April.
My lord,
Let it be,
28th.
because 28th April.
17,
28, 20.
20. 17,
NDPS,
NDPS,
case
ma'am.
diary. The same scan. This can copy the relevant pages of case diary relevant to the petitioner produced on 3rd May.
18,
Yes.
NDPS 22C.
Okay, same date,
My lord.
3/5. Case diary.
19,
I believe the lordship,
Yes.
put it in the resolution, resolution 376, reading section 4 of Fox Act.
Okay, case diary.
My
You declare case diary, yeah. From which place?
He stayed,
Dhubri,
he has support PS case.
3rd May.
My lord,
Everywhere scan copies.
my lord.
And statement of the victim girl. Yeah. Statement of the victim girl under 161 and 164 CRPC and medical report, if any. Just make it scan copies.
20,
Yes,
There is also 22C, my lord, NDPS,
22C.
my lord,
3rd May.
my lord.
I've called for the case, right?
for
3rd
motion,
May, 3rd May,
3rd May, 3/5,
3/5.
3/5.
for motion 21,
That is your lordship. The allegations under Child Marriage Act, person, and the parent, praying for the parents' care. At the time of marriage, the girl's age was, sure, her birth of date was 1/1/2007.
7.
2007, 1 January 2007.
Should
She
we
got
still,
married on 25/1/2020.
she'll be still a minor today,
Yes, 16 years. More than,
17.
yes.
She'll be a minor today, right? But it is 1/1/2007.
1/1/2007, will pardon.
7 will be 8, 9, 10, 11, 12, 13. She'll still be a minor.
Minor, my lord.
Let the case diary be
This
produced
is
there.
my lord.
Scan copy of the relevant pages of the case diary relevant to the petition we produced on 28/4.
My lord, 24.
Okay.
22,
This matter was taken out after some time.
What is the age of the girl?
The file is with my colleague, so he is in another two.
Okay. You're also 1/7/2007. Okay, after some time. She was a minor at the time of,
Minor.
still she is a minor.
23,
23 lordship, he also allegation under Child Marriage Act lordship. FIR your lordship will find page
Oh,
8.
age of the girl, I'm more interested in age of the girl.
Yeah, actually, lordship, marriage was not solemnized, but I have enclosed her birth certificate also, which is also contradictory to the FIR lordship.
Where is that?
1/1/2006, page 14 lordship.
1/1/2006. Six will make her. So she'll still be a minor.
But yes, marriage was not solemnized, Lordship. And if your Lordship sees the FIR page 12, even he is regarding age also, he is stating contradictory facts, and when marriage was solemnized, that is also in stating contradictory. Because he says since 2020, he saw the girl in the house of the LS, in her LS matrimonial house, Lordship. And in below upon your Lordship will find that she informed that 2 years ago marriage was solemnized. That cannot be, Lordship.
There is a statement that there was no marriage.
Page paragraph 4, Lordship. LS husband was arrested and he was granted bail by the court below, Lordship.
Where is that order?
That order I could not annex, Lordship. That statement is there.
Where is that?
Paragraph 5, Lordship. I'm sorry, Lordship. Paragraph 4 itself, paragraph 4, page 4, Lordship. Last part, first paragraph. It is pertinent to mention here that in connection with the present case, the accused number 1, Hafizuddin, that is son of the petitioner number 1.
That
was
is interim bail more than.
Right.
Mr. A. Ahmed, counsel for the petitioner, there is child marriage. Apprehending arrest in connection with so here is bail for 38. Given interim 50,000 same conditions. He's ready on.
Minor, then as interim is the minor, May minor, fourth May.
Third May,
Third May.
third May.
24,
The conditions.
24,
Oh, no.
The case was initially registered under section 363. Subsequently, Lordship, child marriage act and act and POCSO has been added. My lord, at the time
Where
of
is the
marriage,
FIR?
my lord, FIR is at page 9.
No, here we'll have to call for the case diary because the allegation is that she was kidnapped.
In
My lord, subsequently marriage and I have annexed the documents. Page,
No, that is okay, but once the father says that she has been kidnapped.
my lord, at that time, there was an allegation. Subsequently, Lordship, this in the month of March 2023, Lordship, the child marriage act and
No, there is another reason why I'll have to call for the case diary. At the time of marriage, the girl was a minor.
my lord.
Apparently, she was a
My
minor.
lord, 17 years, 6 months, 20 days. Lordship.
She was a minor, but look at the certificate at page 15. She is shown as 18. So therefore,
My lord, page 14 is the school.
page 15, page 15.
Yes, Lordship, that is.
18 years she is shown. So she is shown as adult and then married.
My lord, all are family members.
No,
Lordship.
no, case diary. Scan copy there. 28/4.
minor 20.
My lord, can it be any other day except 28, Lordship?
20.
Okay.
2nd of May, Lordship.
Second, I have a pattern matter. Third then.
Then third.
of Lordship.
25,
May please, your Lordship.
Here I'll call for the case diary because in your vehicle, it's not for cattle.
Lordship, I have annexed the cattle pasture receipt, Lordship. All the,
The vehicle is not for cattle, transporting cattle.
that is true, Lordship. It will attack 11D of the Prevention of Cruelty to Animals Act is available, Lordship. And Lordship, I have annexed all the cattle pasture receipt, Lordship. So the Assam cattle act is related, Lordship. If the cattle is purchased from the registered market, there's no permission is required, Lordship. The Lordship, kindly see page 12 onwards, Lordship. It's all of the cattle pasture receipt. They have purchased the seed cattle from Lordship. One government market, Lordship, government registered market, Lordship. It's called Lordship, Shilapathar government registered market, Lordship. If the
No,
cattle
but
is-
you see, you could not have engaged your vehicle for transporting cattle. It's not meant for cattle.
Yes, Lordship, that's absolute, Lordship. It affects section 11D of the Prevention of Cruelty to Animals Act, Lordship. 11D, the overload, Lordship, is that is carried by non transportable vehicle losses, it will attract section 11D of the Prevention of Cruelty to Animals Act losses, which is available on losses. So for losses 379 losses, it is not
Just wait,
attract losses.
just wait. Yes, that is right. You'll give an interim then.
my lord, but in one vehicle, 21 numbers of my lord.
It's okay, but you find out 50 rupees.
My lord.
What can you do? You write, if you can show otherwise, then any other section is attractive. Okay. Mr. T. Chudial and counsel for the petitioner. And Mr. Vidyut Sharma and ABB for the state. A pending arrest in connection with so and so, here is bid for 38. The learned APP has opposed the prayer for bid on the ground that the petitioner, the vehicle of the petitioner was being used for transporting 21 numbers of cattle. And that the vehicle was not registered for transporting cattle. Next, that the case diary be produced on so and so. On a consideration that if cattle is transported, otherwise then in accordance with law, the provisions of section 11(1)D of the Prevention of Cruelty to Animals Act 1960 would be attractive. No, but not, we still will not give grant you bail. Mr. Jitia,
Okay,
we will always be fair to the court.
okay,
You should not make me read it,
okay.
correct?
Okay.
You have second time said that only 11(1)(d) will be attracted and it is bailable.
Okay.
What about 13(1)?
Lots of Assam Cattle, your Lordship, kindly see the section 7 of the subsection 5 Lordship. It refers Lordship if the cattle shall be transported in the manner that's sort of animal rule 1978 Lordship.
So penalty will be under 13(1).
No, Lordship.
13(1) is
No, Lordship,
13.
Lordship, the center like Lordship, the prevention of cruelty to animal.
No, there is an Assam Act.
Lordship, 1978 rule is under the prevention of cruelty to animals act Lordship.
Under 13(1), what is the punishment?
Under 13 only non-bailable, but Lordship.
So therefore you should have told me that
But
both the
Assam Cattle
sections.
Preservation Lordship, Assam Cattle Preservation Act, section 7, subsection 5 itself says that the cattle shall be transferred in a manner transfer of animal rule 1978 Lordship. If the that rule is violated, Lordship, then section 11(1)(d) Lordship will attack Lordship.
No,
If the
because in the Assam Act, there's a requirement that there should be, the car should have it should have the permit to carry.
permit to carry Lordship, Lordship, then Lordship, Lordship, kindly say section 7, subsection 6, clause 2 Lordship. There is no
No.
permission is required. If the cattle is purchased from the registered market,
No, no,
no
no,
permission is required Lordship.
that is permission to trade.
Lordship.
Permission to carry something else.
No, Lordship, the Assam Cattle Preservation says that if the cattle is purchased from,
No,
there's
no,
an
no,
exception
no,
Lordship.
no, no.
There is an exception Lordship.
No, don't tell me, because now I have read. Once I have read it, then I understand it perfectly.
No, there
You
is an
see,
exception
under 714,
Lordship.
whoever transports or causes transported cattle in contravention of provisions of 1 to 3 of such vehicle or conveyance used so and so, cattle shall be seized by authority under specific under section 11.
Okay.
And then the penalty under section 11. Sorry, this 13. It says anybody who's contravenes 4, 5, 6, 7, and 8 shall be guilty of offense punishable under so and so.
It will be attacked only Lordship when the
No,
cattle
that is
transported
something
to-
else. After the case diary comes, then
Yeah,
no,
Your
no
Lordship,
entry.
kindly, Lordship, if the cattle is transported to the district, Lordship, which is served by the international boundary.
No,
then
no,
section
conditions
13
of permit of the vehicle it is attracted. Once I read it down, I understand.
The Assam Cattle Preservation Act, section 7, section 5 itself says
No,
that
no,
Lordship,
no entry.
cattle shall
No
be
entry.
transferred in a
Case
manner.
diary. No entry. Case diary. Because you made me read this. Believing you have started dictating and then I was passing an order,
Okay.
but you did not tell me about 13(1).
So
You
13
can
also attack, 13 only attack.
It's okay, you should have told me. I'm not
13
granting.
Lordship, 13 only
I am
attack.
not granting.
Okay.
If you want a rejection, I'll be passing an order of rejection. You want a rejection?
No, Lordship.
No, that's right. Once you would have come in clean hands, I would have given you.
Fine.
Once you make me read it, and then I understand the actually it is different.
Lordship, section 7, 5, it will attack Lordship, the 11D Lordship, if the cattle is transferred to the
You may
District
argue on
to the-
merit. You may argue on merit, even without the case diary, you'll be able to handle it.
Lordship.
If you argue on merit, you can do it.
Only Lordship. Only.
Case diary 20, make it 28.
20.
Can it be shorter Lordship? 22
No.
Lordship.
24 is a holiday, that's why we are included. 26, make it 26.
26.
Okay, there are two other matters of the same,
Same level Lordship.
27, 28.
Okay.
Yes,
26,
Same there Lordship.
same day.
Only
26,
Maybe this was it. My senior
Yes.
this against another court. This can be further matter.
I think 27.
Sometimes.
Okay. After some time.
Oh, yes.
Okay.
29,
Lordship, 438 legislation Lordship. FIR is 10. Elevation under section 9, 10, 11 of this.
Just one. Where is the FIR?
Page 10.
Okay, yeah, here are the granting interim. I'm granting interim in this matter. By Mr.
Yes, Alam.
S. Alam, then counsel for the petitioner. And Mr. Vidit Sharma and Detivi for the state. Child marriage. 438. Interim, same amount, 50,000 with the conditions. Is ready on
third one, then
Three five.
Most of this.
Okay, sir. Yes, Mr. Chaudhary. I've called for the case diary. The date has been given. I don't remember the date. Case diary has been called for. This was NDPS matter, right?
And this is NDPS
I've called the case diary.
Item number 1 for admission.
In this case, my lord, petitioner instructed me to withdraw the case.
You want to withdraw it?
Yes, my lord, with a liberty.
Uh, No, but why is liberty required? You can't challenge the advertisement of 2016 again.
That was not my, but subsequent, if any further action.
Subsequent cause of action, you don't need that liberty, correct? Because you are challenging 2016. Once you withdraw it, you can't challenge 2016 right now because 7 years have gone by.
Yes.
Upon instructions, Mr.
K. Kolita.
K. Kalita, and counsel for the petitioner, seeks to withdraw this petition. Secondary, who is there? You are there? You're for secondary education? No. You, Mr. U. Sharma, the standing counsel for the secondary education department is present. That is just dismissed from withdrawal.
Obligation.
2,
If is your lordship, my lord, may I pray interment of after petition?
Just a moment, there's something, which is. Mr. Ravi, you are praying for BTC.
Yes, my lord.
Now this, insofar as this position, land position is concerned,
Yes, my lord.
you are, in fact, in your affidavit, you are admitting that part.
Yes, my lord. We have filed affidavit, my lord.
Yes, yes, from your affidavit, I'm saying, one of the grievances of the petitioner is that their land was taken away.
Yes, my lord.
This part, you are admitting.
I mean, I know. The whole of them. Let's see.
Correspondent number 6, go for the government who is appearing.
Yes, K. Das, my lord.
Government who is there? You are for the government?
Peace Oikea is another court, lordship. Lordship, Peace Oikea is another court.
So Saike is another court. We'll wait for some time. Let the government advocate be there. You are for 9. In your affidavit, have you said anything about the land? you-
My lord, we have said that everything we have removed from that complex, from the complex of the petitioner's school. Only one, my lord, a tube well and my lord, I will see. One is some part remains and we will remove that part.
So far as the BTC is concerned, my lord, we are not taking a contrary position from them.
That's why, because I'm only concerned with the land. You said that land was taken away. That part you say that that part you admit, but you say that it is for the what you call the land revenue department authorities to say.
Yes,
So what about the land position? That is the only question. I
that
was-
needs to be given a clarification from the circular.
Yes, that's right. We'll wait for some time. Because unnecessary matters are pending for small issues.
Civil in Nassar, my lord.
No, civil is okay, but if you assert the land, if the land position is taken away and it's a school,
Yes, ma'am.
public interest will prevail. So if
Our son is also school.
if I know how to write an order, even a civil dispute can be converted into 226 and taken up because public interest is paramount. Because you see, once the government takes away the land, let us assume for the time being that their position is correct. Land is taken away. Then what happens? The school collapses. The school won't be able to function because the school needs own land. So therefore, there is a way to close a school. Even if the school has one student, there is a public element of public interest there. Because if you search the net, you will find the place I forgot. In a place where it is very hostile region, therefore one student, the government is operating a school bus, bringing the child, taking him to school, educating him and returning him back. So even for one student, the government has a duty towards the students. Public interest is there. So only that land issue, I wanted the government advocate to.
Otherwise, our son is also school. My lord.
No, it's okay. Against you till now, I have not taken an adverse view, just the question of land. I'm more interested in the status of the land for the time being. After some time,
My lord.
the government advocate will be there.
Three,
Lordship made cases, my lord.
Yes,
Lordship, your pleadings are complete, your lordship. May I pray
Yes.
for taking up for admission hearing immediately after view holidays, my lord?
no, just a moment. This.
Fine.
What is your stand? I could not understand your stand in respect of that NetSled PhD.
Yes. your
What is your stand?
My case is that when I was like selected, my lord, rule was different, my lord. Rule that next letter PhD, my lord, or MPhil. I had MPhil, I was selected, I was approved by the governing body, which was challenged by a petition by one of the unsuccessful candidate in the early writ petition. So your lordship, subsequently, your lordship, that writ petition withdrawn by that candidate as she got appointment in some other college, my lord. And since then I approached this one higher authority, director of higher education. Then they have taken the plea, they issued impugn order stating that the lordship rule had changed.
But if the rule has changed, you'll have to comply with it. It's the direction of the Supreme
It's
Court.
different, your lordship. I'll try to satisfy your lordship, my lord.
Okay. Also, is that represented on the prayer made by Ms. B. Bhuyal, senior counsel for the petitioner, assistants John today, based after answering due vacation.
Nice.
four,
May I please, your lordship?
Yes,
The petitioner has expired. The matter become infructuous.
okay. Upon instructions, Ms.
B. Talukdar on behalf of M. Bhagavati.
B. Talukdar, learned counsel appearing on behalf of Mr. M. Bhagavati, counsel for the petitioner, submits that she has received instructions that the petitioner has expired, and accordingly, the matter has become infructuous. Accordingly, just right, Mr. Armazundar, understanding us for the Secondary education
Second.
department is present. Matters are dismissed and having been read in infractions.
leftover 22.
I'm sorry, madam. Other-
No, it's okay, it's okay.
But this is a child marriage,
Yes,
and your lordship kindly see the FIR, my lord. Father and son before your lordship.
yes, but the girl was still a minor.
She's mine. Now, of course, her age at the time of marriage, my lord, the FIR is 15 years, 3 months.
So
As
she'll
per-
still be a minor.
As per certificate, but pregnancy also, 4 months pregnancy is there. Now, I have also referred my lord one judgment, I have referred to other high courts, although your lordship is not bound. But some observation is there, my lord. Page 9, I have annexed it, my lord. And we just come to Supreme Court also, my lord, that also page 18, your lordship kindly. Page 18. I take to your lordships to page. Page 20, my lord. Very good, man. Here, madam, love marriage, she allowed with the petition, madam. No complaint from any point. Paragraph 14, your condition, madam. Court cannot be a silent spectator to turns back on the disturbing distressed family. If the impugn FIR is not quashed, petitioner will have to face the incarceration for the last 10 years. The mistake or blunder which otherwise constituted an offense has been committed due to immaturity of so and so emotion of 2 years persons. Then thereafter, your lordship, the paragraph 15, some reference was made to other high courts also, my lord. Then paragraph 17 also some high courts referred. Then this has come, my lord, on the challenge to the Supreme Court dismissed and allowed this, my lord. This is page 23, the my lord, page 19 is the accept, my lord, the last concluding section, my lord. Section 9 may better, but POXO and 376 is not at all. And Father is also here, petitioner one of which.
But Mr. Chaudhary, you are showing a judgment where opposite has been laid down by the Supreme Court. I don't know, but in this case, the SLP were dismissed. But
Supreme Court upheld this one.
no, that's why I'm saying SLP were dismissed.
So the fight was filed other one.
No, it's okay, but I
So
won't
ultimately
say,
this was upheld.
no, I won't say it is upheld because that finding is not there. Only SLP is dismissed.
So ultimately SLP dismissed my lord, somebody is
No.
challenging this order.
No,
We may, my lord, of course.
no, it's okay. But technically, you see, that is, we can't say it has been upheld.
But Supreme Court are normally SLB decisions, nothing, they do not mention anything.
I understand, but you can't go ahead. Nobody can
Sometimes we
possibly-
go after very preparation, my lord, one line.
No,
SLB
that is
dismissed
okay.
and allowed.
I'm not on that. But you see the judgment which is penned down, absolutely opposite has been, is the judgment of the Supreme Court. It says that when POXO is attracted, subsequent, what you call, arrangement between the parties would not absolve him from the offense.
That also my human aspect matter because ultimately they both of them might have they ultimately they went. The marriage is a solemnized matter. Now whether POXO and 376 also is there. Matter fact is that your lordship will find matter so many cases are this type of cases are there, man. Now what will happen to them, man? 4 months pregnancy is also there. Man. But they have done my lord. Nobody is supporting my whole thing is but suddenly it was done. So for the ends of justice, my lord, if somebody, my marriage is also not void, my lord. Marriage is not void. It is voidable. Your lord kindness,
Yeah.
my lord.
There's an old Hindi song. Mr. Chaudhary,
My lord.
there's an old Hindi song. वही होगा जो मंजूरी खुदा होता है.
वही होता है जो मुझे पता. So जो कुछ हो गया. Sometimes now it happens, my lord. Your lordship is very right, my lord. जो होना है हो गया.
She is minor at that time also, my lord.
She's still a minor.
Minor.
Still a minor.
And in para 4 also they have not mentioned on which date their marriage was solemnized, my lord.
Yes, paragraph
That
4
was also not mentioned there.
love and share
4, my lord. Para 4, my lord.
So let us should not stand in the way of love affairs, man.
No, because this is leading to a what you call very bad situation.
That's true, man. That nobody approves it, man. I am not approving, man. It happens, my lord. This is what I am to say. And now people have become alert, my lord, because of this type of this, my lord, the steps taken by the government. Now they have, everybody is now very much alert. And nobody is going to have it. So I think something happened, my lord.
No, but it is right. You don't give a date of birth to
Yes.
marriage.
Marriage,
not?
my lord.
Oh, marriage, October, my lord, this.
But why dates are not given?
October, my lord, 22, I have given. My paragraph 4, mid
No, but
of
the date is not there.
middle of part of October, that was, he also could not say
Because
exact date.
even few days back I said, there's been 30 years of my marriage. If I forget the date,
My lord.
But I also cannot say my date of
surely
marriage.
I land in hospital.
But I forgot my date of marriage.
That's why I am remembering this, my
No, because if I forget the date of my marriage, I would be in hospital. Nobody can save me.
We asked him repeatedly, said October, this, which,
But then we can't give you bail. You must go and find out the date.
but
At least the
middle
date of-
is 15 October, your lordship.
No, not this. But if you forget your date of marriage,
Oh,
we should, you have to come back and tell us.
I asked my wife, she remembers it, my lord, but actually, so she sometimes remembers, yeah, tomorrow is our date of marriage.
No, there are many young people sitting behind
They are very much aware, my lord.
who would like to enjoy
Celebrate it, my lord.
would like
anniversary,
to
marriage anniversary.
marriage anniversary of yours. They would like to celebrate with you. Why you're depriving so many members of the wife of that?
But I should not stay in the way of that, my lord. Let them celebrate. Lift your lordship, my lord. This type of case, your lordship, I think borderline case, my lord, your lordship.
Given entry, Mr. H.R. Chaudhary, Senior Counsel, assisted by Mr. Ayu Chaudhary for the petitioners. Only one petitioner?
Two petitioners, father and son.
Okay. Four 38. Interim bid, case diary on. Which date?
My lord.
Third May?
My lord.
Sunday?
My lord.
3rd May, okay.
Obliged.
Uh,
22.
Complete drawing, I think, marginal.
My lord, second petitioner is Sohirul Islam, my lord.
Yes.
His Parak's husband,
Son, my son.
his son.
Yes. Number one is father, number two is son.
Interim.
They will appear within. You must have said 10 days.
It's the same within 10 days.
Obliged.
I think within 10 days.
Obliged.
Then I think I should call Mr. Khan also and give him the bail. If I have given bail to Mr. Chaudhary, I should not deny bail to item 24.
My lord.
That's it's okay. Okay.
Obliged. Obliged.
26.
I'm sorry, Lordship, I was on level.
No, it's okay. It's okay. 22C will call for the case diary.
Lordship. My little submission, Lordship, and the petitioner father is 85 years old and he is in bedridden condition.
Oh, we can't help it.
Lordship.
We can't help it.
He is a license holder, Lordship. And the petitioner is a license holder. I have
No, but that quantity you can't hold. You are a pharmacy, right?
Lordship.
In pharmacy, you can't hold that much of quantity.
Actually, Lordship, and my one employee, one Vipul Ali.
No, those won't go. Case diary.
My prayer is short date, if possible, immediate after,
3rd May,
My lord.
need the Lordship this month.
and this month, okay, 28th,
Lordship.
28th May, April. Okay.
My lord. 28, my lord.
Obviously.
Five. Release item number 5.
Here, please, your lordship.
Yes,
Lordship, in this matter, the petitioner was appointed as a cook in the year 2006, lordship. And after that, since she objected to the wife of the respondent number 5, respondent number 4, as she was appointed as a cook in her place, she was discontinued from her service since 18/5/2015. And now, even after all these years, even though she's continuing, she is not allowed to sign the register.
no, but you see, your grievance is against the,
Respondent number 4,
against this managing committee of the school, right?
against the president, lordship, respondent number
But
4.
how would writ be maintainable against him?
Against respondent number 5, lordship.
No, how would a writ be maintainable? Because
But
this relief is something which the state government will not, you are not wanting from them. The approval must be made by the president of the SMC.
yes, lordship. Lordship,
But then-
Vakalat number has been filed by respondent number 4 and 5. Yeah.
No, that is okay, but you see, writ is to be issued against the state. This president. You have to demonstrate that this president would,
Lordship, we have made the parties,
no, making a party is okay, but you see, you'll have to demonstrate that this writ would be enforceable against this person. Writ can be issued on against a state, that is no difficulty, but whether the president will be a state within the meaning of Article 12. That is something we'll have to argue and demonstrate. Are you prepared in that?
no, lordship.
Then I'll adjourn it. You be prepared, because you see, here your relief is directed against this individual. You have named respondent number 5 as an individual. So therefore, you'll have to demonstrate that this individual, respondent number 5, is or can be within the scope of Article 12. It has to be state that you'll have to demonstrate. Next time you argue on that.
But lordship, we have previous orders.
No, that is okay, but if the president doesn't want to do it, can a writ be maintainable? That is something I'll have to argue. If you are prepared, you can proceed. If you are not prepared, we'll adjourn the matter.
Okay, lordship, then short date may be given immediately after the vacation.
Okay. It appears. Your name, her miss,
Review Nanda.
You Nanda, counsel for the petitioner. Mr.
I am respondent number 5, Lordship.
If Colonel Standing Counsel for the Elevated Education Department,
1, 3 and
representing
4.
respondent numbers 1, 3, and 4. Mr. F. U. Barbuer and counsel for respondent number
5.
5.
And for respondent number 2.
Mr. P. Nayak, Learned Standing Counsel for the Finance Department, representing.
SSA.
SSA representing respondent number 2. It triumphantly appears that the grievance of the petitioner is that despite orders passed in the writ petition as well as in the contempt petition, the respondent number 5, who is the president of SMC of number 191 Desh Bandhu Memorial LP School, has not allowed the petitioner to join as a cook
Yes, Lordship.
in the said school. Full stop. Therefore, the court query is to the effect that whether order in the nature of writ can be issued against the respondent number 5, who is an individual. Next, on the said query, the Learned Counsel for the petitioner, press for granted time to address the court. List immediately after the ensuing bifurcation.
Lordship, date may be given.
Date to be given. Let's see if you can accommodate, give a date.
26 for
26.
Mr. Nayak and Mr. Fukan, what is your tentative view about this? There's an order of the court contempt on facts. What is your tentative view in the matter?
Which matter?
This last matter.
Last.
No, this matter.
This matter.
I have closed this matter, but I'm just wanting to understand your stand of both of you.
In fact, I am appearing without the brief, my name is also not reflecting in the cause list.
Just right. The registration reflect the name of Mr. P. Nayak as standing counsel for SSC while listing the matter next. You see, she was a cook. She was the petitioner is a cook. She was removed. They filed a writ petition. There was an order for directing to restore. It was not done. There was a contempt petition. Contempt, there was a direction to comply with the order. Now this SMC president is not allowing her to join. Now this SMC president is an individual. So therefore my query is that whether he can be order in the nature of writ can be issued against him. That is number 1. The second part is what is the departmental view in the matter about when there's a direction of the court to allow her, the petitioner to join. What is your tentative view? If you have read this.
First thing, Lordship, whether that particular SMC president was a party in the writ petition or not, that is the.
No, now is the writ petition. We are now hearing a writ petition.
the
He
context.
was party earlier.
In that contempt.
Earlier, you see
petition,
whether
is
they are
the
not, there or not, I'm really, if you see, when I read cursorily, I don't go deep into the matter. Just overview and then be here because education is something new to me. So privacy, I read the file, I don't go intrinsically. But the fact is whether they are party or not, I am not seen. But the issue is that when there's a direction of the court and there's a contempt order also. Now, will the technicalities come into the way of issuing a writ? But the writ is against the. I'll give you the second file. Just so I couldn't make out. I did not have a clarity.
I am providing.
Okay. After some time, just to give an overview because I wanted an independent view in the matter. After some time. The matter is closed. I'm just hearing Mr. Nayak just for clarity. And Mr. Nayak, I've got no urgency in the matter. If you have another work, you can go and come back. I have no urgency that I need it right now. Even at the end of the day, you can just tell me.
Not on the next day.
Huh?
On the next day, our matter is closed.
Okay. On the next date, you'll, okay, okay, okay.
After opening lots.
No, I've otherwise fixed it. I just wanted a clarity because this is, although I posed this question, but I needed some clarity in the matter.
On the next day.
On the next one, okay, okay. I've got no urgency in the matter. Okay. I just wanted to understand. That's all.
Definitely, like, I'll try to.
6.
Okay.
Yes.
Order dated 16/3/2018, my lord.
It's 6 to who? John. Oh, it's 6 to.
Item 6, body chair. I will read petition as well disposal.
Yes, it has to be sent to the Deputy Commissioner for examining.
Yes, it was sent to the Deputy Commissioner for examining. Madam, I've just placed another order, madam. I have given a copy of the, the other school had filed a repetition in 2020. Based on that, already all the benefits have been directly given to that. That school did not, let me come back. That school did not make them a party. So that has been disposed of. He has made that school a party in this repetition to determine the genuineness. But the other repetition, my lord, the order has been passed that the other school is genuine and therefore all benefits should go to that school. It is only to bring it to his notice. He might require that.
Suppression of
that, my lord,
they have taken this order. Because I have made them party, they have
No,
not.
that is okay, but you know your remedy.
Yes,
I can't do anything about it.
they,
He's just bringing it to your notice.
If we bring that, if we take that order into consideration, this repetition will become infractions.
Just become infractions.
because I am a necessary party in this, that will be there. I have made
but-
them party.
But you know the remedy. I can't do anything about it. In this situation, I can't touch it. I can merely read the order, but I can touch it.
Challenge them. Resume.
Necessary party, party will not legislate, I'm not party.
Also, it's a DD representative, Mr. R. Mazumdar, and it's standing also for the Elementary Education Department. Has brought to the notice of the court that the respondent number 6 school had approached this court by filing WPC 5293 of 2020 claiming disbursement of arrear financial assistance for the period of 2010-11, 2012-13, 2013-14, and 2014-15 to the respondent number 6 school. Full stop. It is submitted that the present petitioner school was not made a party in this said petition, and this court by order dated 1/11/2022 passed in WPC 5293 of 2020 had directed the respondent number 3, I, the Director of Elementary Education, Assam, to reduce the area financial assistance for the said period, for said period.
The second one, just not related. Well, the second one is perhaps not related.
It's not,
Second one is not related by mistake.
no, it's okay.
But in these two petitions, subject matter is different entirely.
You know, the same thing, based on this order, the court has granted the relief.
So accordingly, the matters to adjourned today to enable the learned counsel for the petitioner to take appropriate action and act accordingly. List after ensuing view vacation. The copy of the order dated so and so. 1/11/2020 passed in WBC 5 to 90 of 2020 is retained and record. You just take instructions. If you are ready to argue today also, I am ready.
Entire subject matter is different. It is different. This is regarding area assistant. That thing I have already got, my lordship. This is totally infructuous order because they are seeking financial assistance, which I have already got, and that is old methods, my lordship. This is I have challenged the order of Director of Elementary Education because inquiry report, my lordship, it is in my favor. And Director of Elementary Education out of nowhere is stated that they were genuine.
We can close this writ petition directing authorities to examine the matter,
Yes, my lord, that is also.
because it will be the deputy commissioner now to do it.
The deputy
Fact finding.
commissioner will only give us an inquiry report for the last order. The one inquiry has to be done by the deputy commissioner. The fact here is that per the order, per
Where
our
is-
inquiry,
Just a moment. This is the inquiry report, right?
Yes, my lord. Inquiry report is in my favor, my lordship. Inquiry report.
That is page 19.
Yes, my lord. Page, yes. Page 19 and
Yes.
page 20 from the above. it
my
will be
lord,
observed.
page 21 maybe, same my lordship, page 21. Here my lordship, after 7 my lordship, 1, 2, 3. If the committee after thorough study of the inquiry report dated 2012-2013 and records of both the school as per findings of hearing 18 to 2000.
No, you are reading where?
My lord, page 21, my
Yes,
lordship.
I am there at page 21.
After point 7, that is the conclusion, my lordship. Conclusion of the committee, my lordship. Page 21.
7, inspection report of Balichara.
Yes, my lordship.
I school so produced by HM.
After that conclusion, the committee after thorough study of the inquiry report. The committee after thorough study of the inquiry report dated 2012-2013 and the records of
Okay.
the school as per findings of the hearing dated 18 to 2015 and considering the entire aspect resolved to recommend the Balichara ME Madrasa village Kanchanbon, that is my school, my lordship. Al Ghafur for provincialization. So thereafter, my lord, I have challenged this order in Annexure 5 page 23 because this order is entirely diagonally opposite to the inquiry report and the recommendation, my lord. How can director by himself,
Show which part is against you.
director of elementary education pass this order, my lord, after the scrutiny committee and the entire the committee which was constituted under the act, which recommended my name, my lordship, director cannot change it, my lordship. And I have made them a party, my lord. They have not come here. They have got the service also is affected. Lordship.
Okay. Earlier order, no, right? Mr. S.B. Laskar, going counsel for the petitioners. And Mr. R. Mazumdar and its standing counsel for the Elementary Education Department appearing for respondent numbers 1 to 4. None appears on 1 to 5. None appears on call for respondent number 6. Although as per office note dated although as per order dated 29/10/2021 passed by the Lahore Court, the notice on respondent number 6 is deemed to be duly served. Next one.
2020 petition আছে।
The case of the petitioners is that the petitioner number 1, Balichara M.E. Madrasa is situated at village Kanchanpur, PO Kanchanpur, in 788152. And it is claimed that the said madrasa was established on 1/1/1986, and its data is captured in the District Information System for Education within bracket DISE for short for the year 2008-2009 with DICE under DICE code 18230109410. First of it is projected that the petitioner number 1 school madrasa is in possession of land measuring 3 bigha covered by this will find it page 4, covered by second RS dag number so under pata number so of Moja Kanchanpur in para 3, page 4. And accordingly, by an order dated 24/12/2013, the Assistant Settlement Officer had issued land possession and mutation certificate in favor of the petitioner number 1 madrasa. Full stop. The petitioner number 2 is the headmaster of the said madrasa. So it is posited that the said madrasa has employed 9 teaching and non-teaching staff. It is also claimed that the petitioner number 1 madrasa had received financial assistance from the government of Assam for the year 2010-11. Next paragraph. The grievance of the petitioner is that respondent number 6 is also running madrasa with identical name of Balichara ME Madrasa. However, the same is located at Borban, BURBND dash Roman 2, PO Baliura, BALIURA, pin 788164 in the district of Hailakandi. The respondent number 6 school, Madrasa, had approached this court earlier by filing WPC 4108 of 2010, claiming to be the genuine madrasa entitled to get financial assistance. And this court, by order dated 16/8/2012, disposed of the said writ petition by directing the Director of Elementary Education Assam, within bracket respondent number 3, bracket closed, to undertake the fact-finding exercise as to whether the petitioner number 1 madrasa or the respondent number 6 madrasa was granted permission and recognition, and to pass a speaking order. Full stop. It is projected that committee was constituted comprising of Block Elementary Education Officer Lala, Block Elementary Education Officer Hailakandi, and District Elementary Education Officer Hailakandi, to examine the claims of both the madrasas and give its report. It was constituted by order dated 18/6/2012, passed by the Director of Elementary Education Assam. The referring to Annexure 2 to this writ petition, comment is Annexure 3 to this writ petition, comment is submitted that the said inquiry committee had submitted its report bearing number DEH-26/BMEM/2013-14/117, dated 2/12/2013. This is page 14. Whereby, after discussing the issues relating to establishment and acquiring of and the ownership of the land, and after verification of the records, gave its opinion to the effect that to the following effect. Page 16, last part, opinion. Thereafter, the district level scrutiny committee and district level redressal committee. Meeting was jointly convened on 20/2/2015 in the office chamber of the additional deputy commissioner within bracket education EDN bracket closed Hailakandi. And the observations recorded in the said in the minutes dated 22/2015 is as follows. Page 20 to 21. Next one. The minutes of the said meeting was forwarded to the Secretary to the Government of Assam, Elementary Education Department, as well as to the Director of Elementary Education Assam. Full stop. Next, the grievance of the petitioner is that the Director of Elementary Education Assam writes by the impugn order under memo number page 23. Memo number so dated 22/4/2016. Had taken a decision to the effect that to the following effect in the inverted comma start. In view of the facts stated above and verifying the records submitted during hearing, the Balichara ME Madrasa, PO Bali Ura, LSC Hailakandi is considered to be genuine. Full stop, inverted comma closed. Full stop. It is submitted that the next the Learning Council for the petitioner has submitted that by the impugn order, the Director of Elementary Education had taken a contradictory stand. Then what was contained in the minutes of the district level scrutiny committee and district level redressal committee held jointly on 20/2/2015. Next one. The Learned Standing Council for the Elementary Education Department. Just that that earlier part of the order and this judgment. By so and so I have given till that copy. So accordingly, it is submitted that not only the Director of Elementary Education Assam had held that the respondent number 6 madrasa was genuine, but by virtue of order of this court dated 1/11/2022 passed in WPC 5293 of 2020, the action has been issued to the Director of Elementary Education Assam for release of area finance assistance for the period of 2010-11, 2012-13, 2013-14, and 2014-15. Next paragraph. On examination of the materials available on record, as well as the order dated 1/11/2022, passed in WBC 5-93 of 2020. It appears that the impugn order in this writ petition dated 22/4/2016 was the basis for this court to decide the WBC 5-93 of 2020. Question. In this repetition, the respondent number 6 has not contested, despite receipt of notice. Postpone. Next paragraph. It is observed from the contents in this case, the petitioner is annexed an inquiry report dated 2/12/2013 within bracket annexure 3. Which was by a 3-member team consisting of Block Elementary Education Officer Lala, Block Elementary Education Officer Harakandi, and District Elementary Education Officer Harakandi, And the said inquiry report was forwarded by the District Elementary Education Officer Hailakandi to the Director of Elementary Education Assam. The opinion expressed in the said inquiry report is already extracted herein before. Thereafter, the matter was taken up in a joint meeting of the district level scrutiny committee and district level redressal committee convened on 20/2/2015. And the observation of the said observation contained in the minutes has already been extracted herein before. Full stop. It appears, it is made to appear that by a forwarding letter bearing number capital DEH dash numerical 2 oblique provin P oblique PROVN capital oblique UP oblique 2013-14 dated 25/2/2015, comma the minutes of the joint meeting of district level scrutiny committee and district level redressal committee was forwarded by the District Elementary Education Officer Hailakandi to the Director of Elementary Education Assam. Full stop. In the said forwarding letter, there is a reference to WPC 4108 of 2010, comma TS number 2 of 2013, before Court of Munsif number 1, Hailakandi, and WPC 1318 of 2014. Full stop. Contrary to the materials available on record, comma, in the impugned letter under memo number so and so dated 22/4/2016, page 23. Comma, the Director of Elementary Education Assam has recorded that the said authority had perused a report of hearing conducted by the Deputy Director of Elementary Education Assam on 9/11/2015 and 21/11/2015, along with relevant records of the documents on the matter. Full stop. This therefore, comma, in this said impugned order dated 22/4/2016, no explanation has been tendered or be given as to why the inquiry, the contents of the inquiry report dated 2/12/2013 and the minutes of the minutes dated 22/2015. How the impugn order is no mention as to why the inquiry report as forwarded on as forwarded on 2/12/2013 and the contents of minutes dated 20 February 2015 jointly held by district level scrutiny committee and district level redressal committee was discarded. First off, in this writ petition, although notice was issued by order dated 16/3/2018, the state respondents in the elementary education department have not filed a response. Full stop. Therefore, there is no explanation as to how could the Director of Elementary Education Assam order an inquiry to be made. And allow the district level scrutiny committee and district level redressal committee to take a decision on the eligibility of the petitioner number 1 madrasa for provincialization and simultaneously also permit the Deputy Director of Elementary Education Assam to conduct a parallel inquiry, parallel hearing which was done on 9/11/2015 as per the contents of the impugn order dated 22/4/2016. Next, under such circumstances, the court is of the considered opinion that in light of the contents of the inquiry report dated 2/12/2013 and the minutes of the minutes dated 20/2/2015 by the district level scrutiny committee and district level redressal committee. runs counter to the contents of the order dated 22/4/2016. So accordingly, the court is inclined to set aside the impugned order dated number so and so dated 22/4/2016, page 23. And direct that the said authority shall decide the matter relating to claim of the petitioner number 1, Madrasa, as well as the petitioner, the respondent number 6, Madrasa, fresh. And pass a speaking order as to and pass a speaking order thereon. Full stop. In view of the contradictory steps taken as indicated herein before, the court further directs that before taking a decision in the matter, the Director Elementary Education Assam shall allow the petitioner as well as the respondent number 6 an opportunity of personal hearing. Next paragraph. It is made clear that this order shall have no bearing on the order dated 1/11/2022 passed in WBC 5293 of 2020. And accordingly, if the petitioner may be well advised, petitioners may be well advised as to action they intend, well advised to the steps required to be taken. In this said matter. Stop. According to the next paragraph, the petitioner shall produce a certified copy of this order before the. You can hear me? No,
My lord?
you can
Yes,
hear
faintly I can hear.
faintly. The petitioner shall produce a certified copy of this order along with a copy of this writ petition before the Director Elementary Education Assam within a period of 10 days from today. And the Director of Elementary Education Assam, within record respondent number 3, shall conduct a fresh inquiry, oblique hearing in the matter, and dispose of the claim of the petitioner within an outer period of 2 months. On the date of receipt of a certified copy of this order. If you have not heard me, I've just narrated the sequence of events. Then the fact that in the impugned order, he had referred to a hearing taken by the DEO. And therefore, I've questioned the decision of the authority in having an inquiry being made. And again, a hearing to be taken by the DEO.
But that hearing perhaps, whatever there is in the order, madam, but that hearing was not directed by the director. What has happened? If lordship would kindly come back to page 23.3, the order of the director. Just above the decision, lordship will see. Just above the paragraph decision, records also reveal that lordship finds where the decision part is given, madam. Just above that, records also reveal the chairman district level scrutiny committee Hailakandi had submitted the particulars of Balishara ME Madrasa Borban, Baliura for provincialization in 13/2/13. to higher authority. So this 15 was never placed before him. 15 was done by the DLSC. How it was done, my lord? That lordship will find that at page 19,
Yes,
at the outset, just after the names are members present are given, my lord, meeting started with Sri M.K. Saikia ACS in the chair. At the outset, Sri N. Das, DEO cum member secretary, apprised the house that some court case related matters are required to be placed before the DLSC and district level redressal committee for proper examination to settle the cases. Thereafter, N. Das placed the court case related matters before the house. So it was never done by the director. What the DEO did was, the orders passed in his repetition was placed before the DLSC again in 2015. And a re-scrutiny was done, trying to recommend his name. The director never knew about this. Director was still depending on the DLSC report of 2013. This never came before him. The sequence appears to be. So therefore, he had a hearing conducted by the DE as per the orders in the writ petition.
no, but this report
Yes,
of 2013
yes.
favors the petitioner.
Pardon?
This report of 2013, this is in favor of the petitioner. You see page 16,
Page 16.
yes,
Yes.
it can't be depending on that.
So this is he's not, this is the inquiry report in respect of Balichara. He depended on the chairman DLS's recommendation of Baliura. The DLSC, the district level scrutiny committee, acts under the Provincial Election Act. This at page 14, the inquiry report is not of the DLSC. And at page 19, this is a
No, but
reconsideration by the
then-
DLSC.
But then tell me, how does this, why did this inquiry take place?
Which one, my lord?
At page 14, how did that inquiry was initiated? It
At
was
page 14.
page 14, that was initiated because of this order passed in 4108,
Yes,
correct?
yes.
4108 says that a fact finding exercise must be done by the
Yeah.
director.
Lordship will find at page 15. I do not have page 16 and 17, my lord, in my copy. I do not know what the finding came to be.
Okay,
But it was thereafter,
You take the second file.
in this my lord, page 18,
Hmm.
only forwards page 19 and rest. It does not forward page 14. It forwards page 19, 20, and 21. It did not forward page 14. The finding of the director is maybe wrong, my lord, that I'm not disputing with all these records being there. But perhaps the director was never put to notice that there was a report of 2014 by the DLSC. He still continued to believe the earlier report in favor of the respondent number 6 as given in 2013 by the then DLSC. In any case, after having noted, my lord, that the land had been registered in 2006 and recognition is given 5 months prior to registration of, and having recorded that he should have rejected the claim of that Baliura. Because recognition could not be given prior to the land being registered. That was the sole ground it should have been rejected. Now, I did not go through the earlier reports or anything like that. I was just on this order and the support given by the other petition.
Okay, now it will be
Otherwise-
too clumsy.
Now, let it be like
No,
this.
no.
I'm just pointing.
No,
out.
no.
You know,
On facts, I should not make an error.
Correct.
After this order is transcribed,
Yes,
in the late hours of the day, please come in. I'll just show you that recast draft.
yes,
Because if the director has not done it,
Yeah.
we should not accuse the director.
yes.
Correct.
Apparently 15 was not before him. That is the only thing I'm trying to
Okay.
point out. 15 was never before.
No, because now if I dictate, it will
Not
become something.
necessarily.
After it is transcribed, that and make the corrections. At the late hours, please come in so that
I'll do.
the order is correct.
I'll do.
Okay. You have a point. You have a point.
Yes. Otherwise, this order is wrong. Having noted that 2006, later on he got a land mutated. The register, the recognition has to be after the land is there, the school is there. Recognition is prior to land and school.
Okay. What after this?
Obliged.
Take a break and come back.
Item number 2.
Yes, I just wanted clarity on the land.
There is an affidavit filed by the respondent number 9, madam. They have saying that they have only one tubewell and one room is there.
Okay.
Up to 95%.
My lord.
Okay, I now remember. I now remember what has happened. On 10-3, on 10-3, I had posed a question to you as to how the writ petition would be maintainable for eviction and recovery of land. That was the issue. Because we also the same query is there, but I forgot the context in which the last time I asked you. You are hearing me?
Right.
So you see, your writ petition is basically for eviction. Now, how can the court be converted into a what you call eviction process? That was the question which I posed to you last time. That is why this land I remembered, but the context I forgot. So this writ petition would not be maintainable. Even if you take an adjournment today, you take it 10 days back. Or 20, it will taken up 5 years down the lane. But still, the issue of eviction of the petition, the respondent number 9, this court will not be going to take up. You file a civil suit and get him removed. Can a writ petition be filed for eviction of respondent number 9? Can a writ be maintainable?
Already, my lord, the petitioner has approached the, my lord, police to attend the police.
Agreed. I have a tenant. I have approached the authorities to evict him. They are not going out. I approached the deputy commissioner, I approached the chief minister, I approached the governor that I want to kick out my tenant. I have approached everyone, police station, local MLA, what you call the municipal corporator. I have approached everyone. Nobody I left. If you want, I can also add, I approached the elementary education officer, secondary education officer. I have approached every authority you can think of. Now this tenant is very adamant. He doesn't want to go. Now tell me the remedy I have. I'll approach the writ court. That I approached everyone. All the authorities you can think of, I approached everyone. But he is not evicting, he is not going out. You can think of anyone.
They have, in their declaration of opposition, they said that they have taken away, my lord, maximum portion.
No, but still, how can the court entertain you? Even if they admit that I want to go out, will a writ be permissible? Even on admission, can I pass a writ for eviction? Let us say they had admitted everything. They will even give a timeline that within 3 months they will vacate. But does it call for order in a writ petition?
Or my lord, may I submit one thing, my lord, we will file representation, my lord, that may be disposed of.
Definitely, my tenant also wants it. Just what I posed this question. My tenant also, I want to evict my tenant. I have given representations. But can the highest authority of the state, let us say governor or the deputy commissioner, can he pass an order on the representation to evict my tenant? Then we close this writ petition. You take whatever steps you want, but writ petition will not be maintainable.
Not today, my lord, because earlier also he have approached which he
No, you see, that is why you please understand my difficulty. Every time I have to read and come, then I forget the context in which I am reading. Every day it's not very easy to read all these files thoroughly and then come to court. What is the point in taking up the matter? You did not pray for an adjournment earlier.
I see, my lord.
No. When the matter is reached, by the time you make a prayer for adjournment, I have already read the file. That is why I now remember I found my scribble so I could understand what the question was about.
After the invitation.
Okay, now let me write in the order, otherwise I'll again forget. Heard Mr. S. Baralan, counsel for the petitioner. Also heard Mr. P. Sekyal and government advocate appearing for the
5, 6, 7.
respondent numbers 5, 6, and 7. And Mr. S. R. Raval and standing counsel for the BTC appearing for respondent number 1, 3.
1 to 4.
So 1 to 4, okay. 1, 2, 3, and 4. For revenue department, who's there? Mr. B. Gogoi. For revenue. Revenue department, respondent number 5.
5 marks.
Acha, Mr. R. Barbuzet, and standing counsel for the revenue department, appearing for respondent number 5. Acha, you will also, Mr. Rabha, you will also appear for 7 and 8.
Yes, my lord, it appears, my lord, the affidavit has been
7 and 8.
filed on behalf of the 7 and 8.
Acha, 7 and 8 also, Mr. Rabha. And Mr. H. R. Ahmed, then counsel for respondent number 9. The Illinois counsel for the petitioner pays for an adjournment. Next para. It is noted that the grievance of the petitioner is that a plot of land was allotted to the petitioner school. And it is claimed that the respondent number 9 had unauthorizedly entered the school premises and took over possession of a part of the land. First off, it is claimed that by the impugn order dated 14/5/2013, the assistant settlement officer had issued a possession certificate in favor of respondent number 8 over a part of land claimed by the petitioner to have been allotted to the school in 1998. First off, the petitioner claims that representations were submitted before various authorities, but as nothing has happened, the petitioner has approached this court seeking a direction upon the respondent number 6, 7, and 8 to restore possession of a part of the land to the petitioner. Next paragraph. In view of the nature of prayer made in this writ petition, on the next date of listening, the learned counsel for the petitioner shall address this court as to how a writ would be maintainable for restoring of possession of land, which is essentially a civil dispute, and therefore why the petitioner should not be relegated to approach the civil court for appropriate remedy. Next paragraph, list after answering view vacations. You have filed your affidavit in this matter.
Lordship, in this matter, we were seeking promotion from the post of foreman to the workshop superintendent. I have some sort of an instruction. He says that there is some order there, an order has been passed promoting him, but I have yet to go through that order whether there is any other relief which we will be entitled to claim, ancillary reliefs. The fact that he was eligible in the year 2016 itself. And his name was also recommended. Thereafter, the DPC held that there is no provision for promotion in the rules. That is what they said. That is what.
That is okay, but because in their affidavit, the stand is taken that you are not eligible for promotion.
No, the rules do not provide for promotion. That is what they say. Not
Oh, whatever be,
eligibility is-
whatever be, I don't,
Let it come up after the after 10 days or a week.
okay. Ms. D. Buragoyal and counsel for the petitioner. Praise for an adjournment, prayer is allowed. Mr. K. Gogol and standing counsel for the higher education department is present. List after ensuing the vacation.
Nine. Item number 9. Nine.
My lord, my senior was here only for the petitioner. I think, my lord, he missed the case and brought in another brief of the petitioner. Which is
Oh, acha. Okay.
Lordship, the 2018 matter, Lordship brought a file today, Lordship.
It's okay.
My lord, with due respect, my lord, my name may be reflected as my upper respondent number 3 and 4, my lord.
Okay. All sides are duly represented. On the prayer made by Mr. A. Ganguly, learned counsel for the petition, the matter stands adjourned today. The registry shall reflect the name of
SG Guru.
Ms. S. G. Barwa as learned counsel appearing for respondent number 3 and 4 while listing the matter next. Your name is shown.
I am for respondent number 5.
Okay, yeah, Mr. K. Gogoi, learned standing counsel for the higher education department, and Mr. H. K. Das, learned counsel for respondent 5 are present.
Mass oblige, my lord. Thank you.
Sorry, my lord, I have item number 2, my lord, I could not attend, my lord. My name may kindly be shown, my lord.
Okay, item 2, what it is?
Sorry, my lord.
10. Item number 10.
Here, I affidavit position.
My lord, I'll have to file an additional affidavit in this person of the affidavit that I had filed. That point of time, my lord, we had stated that the matter is being placed before the cabinet. Now, the cabinet decision has come, many of them have been appointed as teachers and or tutors. But this bunch actually contained around 200 cases tied up together, which have been released very recently. We're trying to find out for each of the cases, and we'll file our affidavits, my lord, in this, stating the position of each of the teachers. This should be, my lord, in 10, 11, 12, and 13,
Okay,
all from the same batch.
12, 13, I am agreeing on it, 12 and 13.
okay. In this matter, you're not there.
No,
In
10,
this
11,
one-
I am not.
None present calling, call for the petitioner. So Mr. R. Mazumdar and standing counsel for the elementary education department submits that during the pendency of this writ petition, the pursuant to a cabinet decision from some of the teachers working in the various lower primary and upper primary schools
Right.
have been accommodated either as tutors or as teachers. And accordingly, the press one is granted time to file an affidavit to bring on record the status of the present petitioners. Correct?
Yes.
First of all. By when? Give a date. It's
The
2019.
other
matter.
matters are being taken up on the 28th of April, sometime after that.
Okay. 3rd May,
Yes.
3/5. And in this next item, item 11, you are there.
No, 12 and 13, I am there.
Acha. 11, who is there?
11. Same council.
Or same council, same order. Give separate orders. Item 12, just reflect the name of Mr. H.R. Ahmed for the petitioner. 12 and 13. Okay, same order,
Same.
3rd May.
Published.
13 looks like I'm getting. 13.
In 13, you are there. In 13, reflect the name of Mr. P. Nayak, standing counsel for BTC as well as finance.
Yes.
Yeah, more affidavit and include.
This
Then
one-
the division that has been done by the government here, what they have done was anybody who got salary for any period of time, even for a day, and was found working, they have all been accommodated. Those who did not have any salary, they have been